James R. Hoffa. Face the Nation. In his first public appearance on a program of this type, you are about to see the controversial General President of the International Brotherhood of Teamsters, James R. Hoffa, face the nation in a spontaneous and unrehearsed interview with veteran Washington correspondents representing the nation's press. Joseph Loftus, Washington correspondent for the New York Times, Charles Von Friend of CBS News, and Douglas Cater, Washington editor of the Reporter magazine. And now from CBS News, today's moderator of Face the Nation, George Herman.
During this past week, the House Labor Committee reported out a labor reform bill by a very narrow vote. It's a House version of a bill which has already been passed by the United States Senate, and some of the members of the committee who don't like the bill say they voted for it just so there would be a labor bill, any bill at all, to reach the floor. And when it finally does reach the floor of the House, the liberals will try to soften it there, the anti-labor forces will try to stiffen it. President James Riddle Hoffa of the International Brotherhood of Teamsters has made it abundantly clear that he does not like the proposed labor bill. Senator John Kennedy says that you, Mr. Hoffa, are the best living argument for the need of a labor bill. And he refers to your many appearances before the Senate's Labor Rackets Committee. For your part, you have now agreed to submit for the first time to this kind of an unrestricted broadcast interview to give the American people a close-up of what you're like and what you think. That's what we hope to find out as we take the first question now from Douglas Cater.
Mr. Hoffa, what is there about the present labor bill that a union with honest leadership can't live with?
Mr. Cater, there are 18 various points in the labor bill that was passed by the Senate of the United States that, in the opinion of our lawyers and the opinion of the experienced organizers and officers of our union, lead us to believe that this bill is not a corrective piece of legislation, but rather it is a punitive legislation. The legislation which, our opinion, will distort the intent of Congress by having loose-knit drafted words made into provisions which no later than today, Congressman O'Hara said on a TV program that it would take years of court litigation to really understand what the vague terminology that is included in the bill will really mean. Our basic objection is that we should have a labor bill which will affect hundreds of thousands and millions of working people and their families. Should be clear, concise, and not left to the question or distortion of legalistic language which may ultimately be settled in a court, but rather draft laws that should be determined as to what was meant and to correct abuses, if any, not harass or try to defeat the purpose of organized labor of being able to assist each other by economic measures or be able to organize the unorganized individuals by attempting to pass punitive legislation. This we object to.
Well, it seems to me then that you're taking a position opposite that of Representative Kearns and some other Republicans who say this bill, as passed by the House Labor Committee, is a victory for Jimmy Hoffa. I wonder, just to get down to specifics, Mr. Hoffa, would you be opposed to the requirement in the House Labor Bill that union officials report on their finances and on loans from the unions?
Today, union officials are required to report to the United States government at least once a year all of the monies that are handled by the individual secretary, treasurer, or president of a local union. There no longer is, nor was there, any secrets for the past several years concerning the finance of unions. The language in this particular law that they're attempting to pass is so broad that it's questionable whether or not the best CPA or the most competent lawyer could advise a union official as to how to file the income and expenditures of a international union or a local union. This we object to.
Mr. Hoffa, all the points you've made so far about the bill is that it's legalistic and would lead to a lot of litigation. Aren't you saying then that your only objection is to technicalities?
No, I'm not saying that. I'm saying, for instance, the hot cargo provision of this bill is a provision which will require one union member to break another union member's strike. I'm talking about the question of reporting, where it is left to guess and left to the devices of individuals to determine what regulation will determine the question of filing income and expenditures. This we object to.
Mr.
We
Hoffa.
want a clear, concise bill so the Secretary of Treasurers who drive trucks during the day or work in warehouses or factories, who do their bookkeeping at home at night, will be able to answer to the United States government a income and expenditure sheet which will not incriminate them out of their inability to understand the necessary legalistic language in this bill.
Mr. Hoffa, we seem likely during the course of this program to want to discuss at several points the questions of secondary boycotts and of hot cargo. I wonder if right now at the beginning of the show we can agree on a brief definition of those two terms which is agreeable both to yourself and to the panel. Would you start off?
I don't know if we can agree, but hot cargo in our terminology means material that either came through a picket line or material that is being handled by non-union individuals at a substandard wage. Or, on the other hand, it can mean material that is being brought into the ports of the United States by low-wage individuals operating ships from other countries, in return breaking down the conditions of the dock workers and the Teamsters in this part of the country. And you talk about picketing. Picketing, in our opinion, cannot be defined by language to where you insert in the provision a section stating that 9 months after a contract is signed, a union may not be able to advertise a substandard wage. This, we believe, is improper, and that if a union signs a contract less than the standard wages of individual unions in that particular industry, then they ought to be able to be advertised and tell the American worker that the company, even though they're under a signed contract, are destroying their wage structure and preventing them from getting increases in wages, hours, and conditions.
Mr. Hoffa, on that hot cargo definition, wouldn't you agree that you also referred to material coming from an employer of employees who refuse to join the union? They have a choice and they decide not to join the union, and you declare the product hot cargo? Isn't that so?
I do not believe, and the Supreme Court has agreed, I do not believe that union members should be forced to handle merchandise against their own individual desires, which they know are being manufactured or delivered by drivers on substandard conditions, without wages, hours, conditions, pensions, or welfare, which ultimately will destroy their conditions. And we reserve the right, and the Supreme Court approved the hot cargo provision in our contracts recognizing individual membership rights.
Now, Mr. Huss, may I follow through with just one question? Didn't the court say such contracts are not enforceable, Mr. Hoffa?
No, they did not.
Mr. Hoffa, how about the so-called shakedown picketing, which would force an employer to recognize and bargain with a union? You're against that too, I take it.
We are not against a provision in the law talking about shakedown picket lines or blackmail picket lines, as the terminology of the Congress and the Senate has stated. We are against the legislation where you're attempting to picture to the United States the fact that a picket line advertising a non-union concern who was paying substandard wages and substandard conditions of saying this is a blackmail picket line. Certainly we're against extortion. Certainly we're against picketing that will create other than a collective bargaining contract. But we are opposed to legislation that will prevent the American workers from being able to advertise to their friends, their fellow unionists, and the American people, non-union employers and individuals who are destroying their conditions that they learn through picket lines and loss of valuable time striking to get decent wages, hours, and conditions.
Mr. Hoffa, this bill passed the Senate by 90 votes to 1 vote. Do you think that the Senate is that anti-labor that it would pass a piece of legislation that does what you say?
Unfortunately, following the discussion in the Senate, talking to individuals concerning this law, I believe that the senators, in passing this bill, while having very good intentions, failed to meet the requirements of recognizing that a labor union is established by free voluntary association, and that individuals have a right to meet, vote, and decide what kind of a contract they desire to live under.
Well, Senator Wayne Morse has said on the floor of the Senate that if the bill comes back to the Senate without a syllable changed, that he would vote for it again. Would you say Senator Wayne Morse is anti-labor?
No, but I would have to say to Senator Morris and to this panel that Senator Morris should spend some hours in a union office or a picket line or in a union headquarters to understand the question of running a labor union as well as he understands his position in the United States Senate and his position as a competent lawyer.
Mr. Hoffa, I think what has troubled more people on the Hill outside of just the technicalities of the bill is the fact that they have heard case after case of alleged wrongdoing and misappropriating of funds, improper actions, that sort of thing within the Teamsters. I wonder, do you still feel that in the face of all this testimony the McClellan Committee has heard that there is not need for some sort of legislation?
Mr. Fremont, friend, there isn't a single violation covered by the provisions of the newly enacted legislation by the Senate that isn't already covered by either state or federal law. There certainly is adequate law against extortion, against any crime that you can mention in the federal books or the state legislation.
What about the hiring of felons in union leadership?
Well, we have no objections to a law that would set up certain requirements to maintain the right to run for office in a union, provided those requirements apply not only to union officials, but to the representative of management.
Well, now that is true in the
representative of Congress and the representative of Senate.
That is true in the House labor bill.
We object to second-class legislation.
Well, Mr.
Which
that
would
is
set
true.
up provisions for labor unions and not for the balance of the American citizen.
Mr. Hoffa, as I understand it, in the House Labor Committee bill, that this provision is made that the bargainers for employers would also be faced with this same responsibility. They could not bargain if they had been convicted in a period of 5 years from the date of the bargaining.
That isn't correct. The House bill will not bar a person with a criminal record whose civil rights have been restored. This is the change from the House bill to the Senate bill.
Mr.
But is that
Hoffa?
not universally applied to both the labor
No, it
union
is not.
side and the...
No, it does not
In what
apply
way is
to
it not
both.
applied, Mr. Hoffa?
What's that?
I say, in what way is it not applied?
Section 405A and B of the law simply states union officials. It does not incorporate the question of management or senators or congressmen.
Mr. Hoffa, are you willing to put the labor movement under the same laws that corporations are under now?
If you're talking about the question of antitrust laws,
More than that.
you cannot include labor unions in the antitrust law when you're dealing against human beings with blood and corporations with stocks and bonds.
No, Mr. Hoffa, I'm talking about the right that the government has to sue an employer who doesn't live up to the wage and hour law, whereas under this bill the government cannot sue a union officer who does not protect the rights of his members. And I'm talking about fiduciary obligations which the labor movement had struck out of this bill. The requirements of a trust, a keeper of a trust.
Mr. Loftus, there isn't a single case in point that you can mention where there isn't a law passed to protect the members of a labor union as compared to the stockholders of a company when it comes to fiduciary relationship between unions and their members, corporations, and their stockholders.
Now, you mentioned the filing of these financial reports that are required of unions. What's so tough about that section?
The section of law is so ambiguous that they leave to the Secretary of Labor the right to draw up regulations and pass regulations which would govern the filing and keeping of records, which are not in keeping with CPA reports that are normally filed by corporations or by agencies of government. We have no objection and recommended that they should use the standard CPA procedure for the filing of reports with the government. This we have had no objections, and you may know, Mr. Loftus, you were there, that we have submitted 51 amendments to the bill in each instance, stating that we recognize that there may have been a problem, that there was a problem. What we believed was a proper correction to the issues raised by the Congress and the Senate.
Mr. Hoffa, isn't not a fact that under the reporting section, the government has to prove a willful violation before there can be any punishment, and isn't it very difficult to prove a willful violation?
This is the Congress version. It is not the Senate's version, the Congressman's committee.
Well, we're talking about the bill reported out by the House committee.
Well, the House committee isn't the bill as that's going to be affecting the labor movement of America. We must take in consideration the Senate bill and take in consideration the House bill also. We cannot just talk about the House bill because this isn't the only subject that's going to be voted on.
Mr. Hoffa, to set the record straight, a moment ago you referred, answer to my question, to Section 405A. I presume you meant 504A, which is the prohibition against communists, ex-communists, and persons convicted of certain crimes. And I call your attention to the fact that it says that no person may serve under these conditions as a this is part 2 of A, as a labor relations consultant to a person engaged in industry, or as an employee performing, or as anything, an officer, director, agent, anything except somebody performing exclusively clerical duties of any group or association of employers dealing with any labor organization. So it does seem to apply both sides, to the labor union and to the employers.
This isn't correct. While you read the document, there isn't anything in this particular law that prevents the president of a corporation, the secretary-treasurer of a corporation, or the board of directors of a corporation from any and all having criminal records and being able to hire an individual lawyer, and the law does not cover lawyers, to do their collective bargaining. In this particular instance, a labor union could find themselves in a position of dealing with an unscrupulous company, having a legitimate lawyer representing them, but by the same principle, have restrictions applying to unions that does not apply to management. And our position is whatever applies to unions in the way of restrictive position holding should apply to management as well as unions.
Then you would flatly accept this if it were made to apply equally to corporation people?
We would believe that the version dealing with the question of the House version of it rather than the Senate would be more appropriate, but it should apply to both.
Mr. Hoffa,
on class legislation.
On another union matter, Mr. Hoffa, there have been recurring reports in the past week that you are seriously considering and indeed planning next September to ask the Teamsters to approve a plan to set up a Department of Political Action under which the rank and file would sign waivers for 50 cents a month of their dues going into a fund which would elect people who vote the right way from your standpoint. This would run to about $9 million a year, which is about 9 times what the Republicans spent 2 years ago in their campaign. Is this correct? Are these reports correct?
Mr. Von Friend, we have stated that it is our belief the time has now arrived to where we must have a department in our international union that will be able to keep our members acquainted with the voting record of congressmen and senators in the United States, so that when they go to the polls, they will be able to recognize the individuals who are either attempting to assist them in being able to maintain their present high standard of living, or those individuals who are desirous of passing legislation that will defeat and eventually eradicate their organizational efforts of the past.
I understand also that Mr. Sidney, I'm not sure of his name, Zagri, I have not met the gentleman, is coming on from St. Louis to head up this job, and that he has performed the same function there in Mr. Gibbons' local in St. Louis for some time now. Will he be in charge of this overall fundraising drive to elect congressmen who vote the right way?
This hasn't been determined yet who will head up the department. Sid Zagri does work for Local 688 in St. Louis, is a competent, qualified man, and the board very well may determine that he will be the individual to head up this department. That decision has not been made yet.
Mr. Hoffa, the fact that this story has come out this week, is this any attempt to persuade or frighten certain members of Congress on the action in the next 2 weeks?
Absolutely not.
Do you feel that, as Senator Kennedy has said, that you are the best argument for the passage of his labor reform bill? Do you agree that the investigations of the Teamsters should cause concern in Congress?
I believe every investigation conducted by a congressional hearing deserves consideration, but I do not believe that a hearing held for the purpose of headlines and individuals to be able to use their position on the committee for the President of the United States should be taken in consideration also when you determine the type of witnesses, such as Mr. Crum they recently had before them, who gain headlines nationwide on certain individual statements, and then no later than 2 days later retracts those statements and nothing happens from the committee. But if an individual Teamster makes an inadvertent slip, he is then charged with perjury and is subject to 5 years in jail.
But a great many of these Teamsters who have appeared before the McClellan Committee, Mr. Hoffa, have taken the Fifth Amendment. I've heard you state your views before as to how this is the right of every American to take the Fifth, and I'm sure that nobody here would disagree with that. But on the other hand, these are questions asked about union activities when the people who are being questioned are responsible for those activities.
Mr. Von Friend, I do not believe that there is any individual who appeared in front of this committee that would not be able to explain his position if he had submitted to him a list of questions that was going to be asked and given due time to research his organization and bring up to date records of 5, 10, 15 years old to answer those questions. But when you ask a man on a spur of a moment, what about a check that was drafted and passed 10 years ago, or a letter that was drafted 2 years ago? You nor no other citizen in the United States can sit there and go from day to day being asked double-edged questions that have not had some experience of appearing in public or some experience dealing with congressional committees.
Mr. Hoffa, you have told the McClellan Committee that as soon as their investigation is over, you personally are going to look into all these cases of alleged wrongdoing. The committee now says it plans to close up shop this year. Does that mean that you plan to go into the cases of Glenn Smith and Babe Triscaro and some of the other Teamsters this year?
It might be well for the public to know that despite all of the statements made by Mr. Kennedy and the committee, that the question of Glenn Smith was resolved in the court, and he was found innocent of the charge. There is no longer any charge against Mr. Glenn Smith, despite headlines, editorials, and after due process, he has been found innocent.
But there are many other cases.
I do intend, however, and as I have told the Senate, that at the end of their hearings, we will expect each individual to come in and have a hearing concerning any alleged wrongdoing with him as an individual concerning his union and make a record to his local union on the findings of the committee.
But do 2 years of hearings convince you that there has been any serious wrongdoing in your union, Mr. Hoffa?
2 years of hearing, of the type hearings that have taken place, convinced me that there is a need for rules to be drafted by the Congress of the United States and the liberal elements in the United States of drafting of rules to conduct congressional and senatorial hearings, so that a man may be able to have the right to cross-examine witnesses and have competent legal counsel at his side, as we have in all of the courts, including justice of the peace courts, all the way to Supreme Court, rather than bring a man in and try and embarrass, harass, and humiliate him by unfounded statements, by accusations, and by individuals who have been committed to institutions, and by individuals who are allowed to change their statements after they've secured the headlines pleasing to certain people on the committee.
Well, we
recognize that there is some problems in the Teamsters Union. Those problems, as I stated, we will take care of by hearings. And it may be well to notify you that, as I have notified the Senate, that out of the 107 names that they submitted to us as individuals who had supposedly did something wrong coming out of their investigation, only 14 of those individuals are left in this international union. And each one of those individuals will have his day to be able to answer questions concerning the accusations with records, due process, and cross-examination.
I think what Mr. Cater wanted to find out from you, Mr. Hoffa, was you say there will be these investigations. He is inquiring, I think, and we'd all be interested to know, you say there will be such investigations. Has any tentative time been set for starting them?
It will be started upon the completion of this hearing with the Senator McClellan, so that they can properly have an opportunity to bring in witnesses, their books, and be able to answer those questions. It might be well, however, while we're talking about this question of the bill, that we recognize the points of problem in this bill, picketing. And when they talk about the question of picketing, you must recognize two things. One, that when they say they're trying to eliminate sweetheart contracts, in fact, they're encouraging sweetheart contracts. Because they say in here that when an employer signs a contract, even though it's a substandard contract, a union may not advertise such to the American people and to workers. will be able to cooperate with the union involved in that dispute.
Mr. Hoffa.
This would destroy unions.
Mr. Loftus has a question which I think you might find good.
Mr. Hoffa, I believe the Teamsters, more than any other union, uses the secondary strike and the hot cargo rule. Is that true?
Teamsters unions are involved in almost every single strike in America. And we have found it necessary to incorporate into our contracts the hot cargo provision, so we will not be involved in secondary provision or subjected to lawsuits over no strikes that we have no control over, Mr.
All right. You said here today that the bill required or would require Teamsters to be strike breakers.
That is
go through
correct.
Picket lines. Now, did not the House committee put in a provision to take care of your objection and say specifically that you do not have to go through the picket line where there is a primary dispute? Isn't that ban really a phony now?
Absolutely not, Mr. Loftus. Nobody should know better than you that under this new particular House bill, there is a provision dealing with the question of picketing. And in there it distinctly states that a driver may not be able to respect the picket line of a machinist, a clerical worker, or any individual where there is the problem of a common carrier having cargo belonging to a third party. It must be picked up and delivered to a consignee.
Yes, and by the way, this is limited to common carriers, is it not, which is a very small percentage of the employers in the United States.
Of course, this isn't true for this reason. Any employer contemplating a strike having a 60-day notice can very well convert from his own type of transportation to a common carrier and then claim protection of this law during the period of the strike and endeavoring to break and destroy the organization involved in that strike.
Mr. Hoffa, many members of the McClellan Committee more or less recognize now that their job is over, but they have great hopes that the court-appointed monitors will eventually be able to force your suspension. Do you think that the monitors will be able to do this?
Well, I think you've laid your finger on the problem with the committee. The committee was more interested in getting rid of Hoffa than investigating an honest investigation concerning the questions involving labor. And I do not believe that the question of the monitors can be settled other than in the Supreme Court where it presently is.
Mr. Hoffa, there's been talk of a prospective tie-up between you and Harry Bridges. If you made such a tie-up, do you agree with those who say you would have a stranglehold over the transportation system in this country?
I do not believe any such thing, and the individuals who make that statement know that it's false.
Mr. Hoffa, you worried a minute ago about substandard contracts. A lot of your friends made such contracts in New York City in the last few years. What are you doing about it?
Mr. Loftus, our contracts are of the highest type of any contracts in New York City, and you know it. And if you take the industries of New York City as a whole and compare any given industry to the Teamsters contracts, and I challenge you to a debate publicly on the radio to prove the statement you just made.
Mr. Hoffa, many thanks for coming here today to Face the Nation. Our thanks also to today's panel of news correspondents, to Joseph Loftus of the New York Times, Charles Von Fremd of CBS News, and Douglas Cater of the Reporter magazine. This is George Herman. Face the Nation will not be seen next week, but we hope you'll be with us 2 weeks from today when our guest will be Governor Leroy Collins of Florida. Our program today originated in Washington.
Face the Nation was produced by Ted Ayers. Associated in production, Bill Coben and Nancy Huntsman. Directed by Bill Linden. Today you saw the president of the International Brotherhood of Teamsters, James R. Hoffa, face the nation. Robert Cromwell speaking. This has been a public affairs presentation of CBS News.